Let me know when you're ready. William? Okay. Good morning, good afternoon, good evening, wherever you may be all around the world. Welcome again to Dr. Olu Asekun podcast. Today is another beautiful Wednesday. I apologize for not being online last week. I had to take a short vacation. One is not getting younger, so we need rest sometimes. So I had to take vacation. Anyway, we are back now. We hope to continue this week as usual every Wednesday, 12 p.m. Dallas time. That is 1 p.m. Eastern. That is 10 a.m. Pacific. And that is currently 7 p.m. Nigerian time. Okay, welcome to the podcast. Today we'll be discussing, what's that topic today again? Okay. Today we'll be discussing visa for nannying. Visas for nannies. Can you please post the topic online on the screen? Yeah. Visas for nannies. That's the topic we are discussing today. So, while I give preliminary information, if you have questions, you remember to send in your question through our various numbers. Can you also post the numbers? You can send 983. Oh, the first one is 817-883-4495. 4495. The second one is 817-983-4499. And the third one is 817-891-6655. Please post all the three numbers online on the screen so that listeners can see the correct numbers. 817-883-4495, 817-983-4499, 817-891-6655. Any of those numbers, you can send in your questions. Today, we are discussing visas for nannies. This is one of those questions that we get. People want to know if they are able to bring a foreigner to come and help them with childcare in the United States. And because we have been receiving the questions, that's why we decided to treat the topic today, how to bring in a nanny or the kind of visa somebody can come in to the U.S. with to come and help with childcare. Okay, there are two categories of visas for nannies. The first category is what is called non-immigrant visas, temporary ones. There are three types of non-immigrant ways to bring someone to the United States to come and help as a nanny. And of course, the second category is the permanent one, which is the immigrant visa. So we start with the non-immigrant visa. Under the non-immigrant category, there are three ways to bring in a nanny to the United States. There are three ways. If you need somebody to come and act as a nanny in the United States, there are three ways to do it. First, a nanny can come with a regular B1 visa. Regular B1 visa. Now, when we say B1 visa, B1 is different from B2. B2 visa is visitor for pleasure. B1 visa is visitor for have a contract. The contract must state how much the nanny will be paid. And of course, the amount of money that the nanny will be paid cannot be less than minimum wage here in the United States. So the option is not for people to bring in cheap labor from abroad. That is not what this is all about. So the contract must specifically state how much the nanny will be paid, and of course, that amount cannot be less than how much nannies are paid here in the United States. So prevailing wage is very important in this case to determine how much does one pay to determine how much does one pay a nanny in the United States, so that the contract will not contain an amount that is less than what nannies are paid in the United States. Usually, this type of option are available for U.S. citizens who work or live abroad, who have this nanny work with them, and then they want to come to the United States and they still want the nanny to take care of their kids. Or even foreigners who live abroad and have been having this nanny live with them and take care of their kids, and then but they have something doing here in the United States that they need to come with the nanny, so they can apply for B1 visa for this nanny. And like I said, usually it is valid for a period of 6 months. It's a temporary thing. It's not meant to be a H2B visa. Is also a temporary visa. It is a kind of visa that is valid for 10 months. It is a seasonal kind of visa. It is valid for 10 months, but it is also renewable. It can be renewed, but it is valid for 10 months at a time. So again, if an applicant or a U.S. citizen or even a permanent resident is desiring to bring a nanny, to bring someone to the U.S. to help with taking care of their kids, they can apply for H2B visa for this nanny. Again, just like the B1 visa, in order to get the H2 visa, they must offer the nanny or the foreigner an amount that is not less than the prevailing wage for nannies here in the United States. In other words, if nannies are getting $15, $20 per hour, you cannot bring somebody in on an H2B visa and then pay that person $10 an hour. That kind of visa will not be approved. So it has to be an amount that is equal to or higher than what they are paid in the United States. It is called H2B visa. And let me say this. For H2B visa, is different from the B1 visa, because for H2B, typically employers or someone desiring to bring a foreigner as a nanny, they are required to offer the job to American citizens first. But of course, this does not require it does not require advertisement in newspaper and all of that, because it's just a temporary thing. It's valid for a period of 10 months. It's temporary, but it is renewable. So that is the second way of bringing a nanny here to the United States. Now, still on the temporary one, the third way of bringing a nanny, this one is what, well, I don't know if this is a French word. I really don't know. Marisa, maybe you can help me with it, the correct pronunciation. I call it APOL. Is it au pair? The spelling is AU space PAIR. How do you pronounce it? Au pair. Au pair. Okay. I mean, I'm not a French person, so you have to bear with me. But I understand it's called au pair. So that, but as far as I'm concerned, the spelling is AU space PAIR. But I learned today that is pronounced au pair. So, so that is the third way of bringing a nanny into the United States on a temporary basis. Usually, the au pair visa, the nanny will apply for what is called J1 visa. So usually, a U.S. citizen that is desiring to bring a foreigner, for this au pair visa, you have a restricted age limit. So the nanny has to be, I think, between 18 and 26. So it is not meant for every age category. It is limited to specific age category. So you bring them, you can only bring in people who are in that category for the au pair visa. So now, what that means is that they are coming into the U.S. to come and live with a U.S. citizen or a permanent resident. Now, they will teach the Americans their own culture, and then while also learning the culture of the foreigner. Now, in this particular case, the US citizen only need to provide accommodation and stipend. This one does not necessarily have to comply with the prevailing wage, because the the foreigner is expected to live with the US citizen in this scenario. So the US citizen can provide accommodation, boarding and feeding for the foreigner, but in addition also offer stipend to the foreigner. If the foreigner desire to go to school, is permitted under this visa to attend school, to go to school while getting paid. In this kind of scenario too, because the foreigner is required to live with the American citizen, the Department of State has a program. They have a kind of protection for the foreigners, because they don't want a situation where people will be abused. So they have a hotline. The Department of State have a hotline where foreigners who are being abused under this program can actually contact the government. Before the end of the program, I will get the number. I think I saw that number sometimes recently. Yes, the hotline to the Department of State, if there is a complaint, is a 1-866-283-9090 at state.gov. J Arena, and you are acting as a nanny for a US citizen and you are being abused, you can contact the government through these hotlines. The number again is 1-866-283-9090, or you can send an email to jvisas@state.gov. Now, there are other requirements for this kind of au pair. How did you call it? Is au pair? Okay. Please, listeners, you have to bear with me. I'm not familiar with this French word. I mean, where we come from, we pronounce things the way they are written. So I would have call it a pair, but they say it's au pair. So the au pair visa, like I said, it is valid for 1 year. It is also renewable. It can be renewed, but at a stretch, it is valid for 1 year. So now we have 3 options. The first one is valid for 6 months. The second one is valid for 10 months. This one is valid for 1 year. However, there are different requirements. Like I said, the au pair is the only one out of the 3 options that allows the foreigner to live with the US citizen, so that they can take care of the children. But the other ones, they may live, they may not. But this au pair visa is specifically required. The foreigner is required to live with the US citizen. So that they teach the American their own culture while also learning the American culture. They also take care of the Americans' children, and in return, the American provide boarding, feeding, and stipends. And like I said, because it is not allowed for every age category, this one is limited to someone between ages 18 and 26. And because of that, that is the age that people go to school. So they are permitted to go to school within that period. So they can be living with the American host while also going to school and also taking care of the children. Now, let me say this. If the American citizen have a child, a newborn baby that is below 3 months old, a foreigner is not permitted to stay with that child alone. The foreigner cannot stay with that child alone. So the foreigner can only stay with the child in the presence of another adult. So the foreigner cannot stay with the child alone in such a situation where the child is less than 3 months old. So it is important to understand all these things. So I think questions are beginning to come in. So let me just go ahead and start answering the questions. Okay, the first question. Are there any limitations of the US visas for nannies program? I don't understand that. I mean, I've started explaining which of them there are. I've explained three different options. Someone can bring in a nanny with a B1 visa. That in such a situation, the nanny is allowed to stay with the person for up to 6 months. Somebody can also bring a nanny with H2B visa. So that is also valid for up to 10 months. And then the au pair visa is another one, and that is valid for up to 1 year. Of course, there are different limitations. There are different limitations for au pair. So I don't know if this one is asking for the limitation for the au pair visa. There are specific limitations. For example, I've said before, the 3-year-old under this program, you cannot bring an elderly parent or grandparent under this program. No, that is not what this is all about. This is meant to as a form of cultural exchange. It's a form of cultural exchange between the American and the foreigner, so that the foreigner will teach the Americans about their culture, while the Americans will also teach the foreigner about American culture. So there are specific other requirements. For example, you cannot bring someone on au pair visa, somebody who is not able to speak English. At least there must be minimum level of English. The nanny must be able to communicate basic English. They must be able to communicate without having to use an interpreter. That's one of the requirements for that. Another requirement, like I said, is that if the foreigner must have minimum of high school. Again, that is to ensure that one, there is communication, because they don't want abuse. That is why these conditions are put in place. In addition, before the au pair visa is granted, an applicant must go through, the foreigner must go through physical examination as a medical. We call it immigration physical. So because they don't want a foreigner to come in and then bring some communicable diseases into the US citizens' home. So the applicant must go through immigration medical, and be certified that there is no communicable disease before the au pair visa is granted. So in addition, usually the au pair, the applicant will go through an interview. They will go through an interview process. Usually, there are some organizations in the United States that help with this kind of visa, and that also ensure protection for the foreigners. So sometimes they conduct interview for this applicant, so as to ensure that the applicant meet all the requirements. So in addition, there must be the applicant must also pass a background check. If you are already in the US on a B2 visa, can a person change status to a J1? For this, there are different kinds of J1. There are J1 visa with a 2-year foreign residency requirement. those who are scholars or those who are working at universities or working with some organizations, those who are sponsored by the foreign government or even sponsored by the US government or a department within the United States and all. So there are different kinds of J visas. But for this particular one, it is usually done through the embassy because, like I said, the Department of State have a lot of things they put in place to ensure that the foreigner is protected and the US citizen is also protected. So they usually, but to be honest, I have not attempted a change of status for somebody who is on B2 to a J1. That is something that I can find out and revisit this question before the end of this program, because I don't want to give you information that I'm not 100% sure of. I will find out if there is a possibility of a change of status to a J1, but I doubt it, especially considering the fact that the other J1s, they have all these requirements. So I will find out and revisit this question. In the meantime, the next question: can J1 get an extension after the first year? Oh yes, for all pair visa for nannies, yes, it can be extended. You can get it is renewable, it can be renewed. So renewal and extension is the same. Yes, it can be renewed. The next question: do the children have to be certain age? No, but they have to meet the requirement of children, because somebody who is 21, for example, is not a child. So they have to meet the definition of children. They don't have to be certain age. The only issue with age is for those who are infant. So those who are infant, the foreigner cannot be alone with those who are infant. They have to be in the company of an adult. They are not allowed to, except where they have at least 200 hours of child care, infant care training. If they have certification that they have been trained on how to handle infant, yes, they may be able to do that. But with the exception of that, they cannot take care of infants alone. They can only do it, excuse me, they can only do it in the company of an adult. So the next question: does the nanny need to be proficient in English? Oh yes, I already answered that. The nanny need to have a minimum of high school, because if someone cannot communicate in English, I mean, if you come here to live with a US citizen as a nanny and you cannot speak English and your host cannot understand you, how are you going to communicate? You can't communicate. So it is important that they be able to speak English. At least they have minimum of high school. That is a requirement in order to be able to communicate. It is also good to protect the foreigner himself or herself, because the foreigner may not be able to file a complaint if the foreigner is being abused without being able to speak English. So it is important that the foreigner must be able to speak English in order to get the OPOR visa. The next question: does the nanny need to be... Oh, I just answered that. What happens to the nanny if the petitioner fires them? Well, usually this type of visa requires a contract. It usually requires a contract between the US citizen sponsor and the foreigner. So usually the foreigner, the contract will explain the terms of reference. The contract will explain the do's and the don'ts, the salary and all of that. And of course, if there is a violation, yes, the employer can fire the nanny. However, usually for every non-immigrant classification, the petitioner is required to provide the cost of return transportation to the foreigner whenever the position ends. This is applicable to every single non-immigrant category. Whenever a U.S. citizen or a U.S. employer is bringing a foreigner to the United States on a temporary basis, the employer is mandated by law to provide the cost of return transportation to the beneficiary if the contract is terminated. Either even if the contract expires at the end of the period authorized, the employer is still required to provide the cost of return transportation to the beneficiary. The next question: is there a limited number of visas for this category? No, because this is a non-immigrant visa. Usually, they are not part of the visa bulletin. Visa bulletin is only in respect of immigrant visas. So these are non-immigrant visas. However, non-immigrant visas are discretionary. So at the embassy's discretion, they may limit the number they approve, but there is no visa bulletin issue with this type of visa. The next question: I was told that a nanny here on a J1 visa is not allowed to travel to other parts of the country, even for a vacation. What happens if the family goes on vacation and needs the nanny to go with them? Yeah, they can go on vacation together. They can go on vacation together. Yeah, they can go on vacation together within the US. That is really possible. They can go on vacation together. The next question: can someone with a working visa sponsor an au pair visa? As in somebody with a non-immigrant visa? No, no. It is available for US citizens and permanent resident. It is available for US citizens and permanent residents. However, somebody who is on a working visa can try the other method. They can try the B1 method. They can also try the H2B method. But for the au pair is for US citizens and permanent residents. The next question: can a nanny get a green card? Well, this question is kind of ambiguous because it depends on the route. If if the nanny decide to go through the H2B visa, yes, after certain extensions, and if they decide to go through the permanent labor certification, yes, it can lead to green card. However, for the au pair one, it may also lead to green card if they go through the labor certification process, because for the labor certification process, there is a category, I think it's called third EEW, third 3EW category of labor certification for nannies. Yes, it can lead to green card. It can lead to green card. The next question: I want to get the J1 or how can I explain it? This is something I've not looked into. I mean, I've not. Now, what was that first thing I was going to check before the end of the program? Okay, so what's the response to that? So the next one is to find out if they can bring a dependent. I'm not sure of that. I will find out again. What did you say? Mhm. That's what I thought, but I wanted to be sure. I wanted to be sure because that's not something that I'm not aware of. Yeah, you cannot bring a child along with you. This is, I mean, come to think of it, you are coming to take care of another man's child. So you need all the attention. You can't be. And again, if we are talking about the au pair visa, this is for somebody within ages 18 and 26 who is also allowed to go to school. So if you are going to be taking care of somebody else's child, you are going to be going to school. When are you going to have time to take care of your own child? So that's not the purpose of the visa. So the purpose of the visa will have been defeated. No, you are not allowed to bring a child along with you. The next question: if my J1 visa for all pair gets approved, will I be subject to the 2-year home country physical presence requirement? Yes, every J visa is subject to the foreign residency requirement. Yes, every J visa is subject to 2-year foreign residency requirement. However, there are some exceptions to it. Number one, you can apply for a waiver of the 2-year foreign residency requirement while already in the US. That is possible. Secondly, there are some J1s that are specifically exempt from the foreign residency requirement. In this scenario, when the visa is issued, it will have been stated, it will have been written on the visa that is not subject to the 2-year foreign residency requirement. This usually happens where the sponsor is not a governmental agencies, or the sponsor is not a public organization, is a private organization that does not desire because the 2-year foreign residency requirement is actually to protect the foreigner, because this is supposed to be an exchange program. J visa generally, irrespective of the kind of J visa, J visas generally are supposed to be an exchange program. So when you come in here to exchange your culture and you also learn the American culture, you are supposed to take what you learn back to your home country and disburse the information, the your knowledge there. So if you stay here, then that purpose will have been defeated. So that is why J visa holders are required to go back to their home country. But again, there are a couple of exceptions, and there's also room for a waiver. The next question: can I change status while on J1? I think we already answered that. Every J1 visa, when it comes to J1 visa, the general rule is that you cannot change status in the US. Even if you marry a US citizen, you cannot change status in the US. That is the general rule. However, like I said, there are some J status that are exempt from the 2-year foreign residency requirement. But for those J1s that are exempt, usually they will write it specifically on the visa. When the visa was issued, at the time the visa was issued, they will have written in on that visa that this person is not subject to 2-year foreign residency requirement. It will have been written there clearly. Secondly, if someone on J visa is able to process a waiver and you get a waiver, then you'll be able to adjust status after the waiver has been granted. But again, if the waiver was granted after you are already out of status, you may not be able to get adjustment through employment-based petition. But if the waiver was granted while you are still in status, employment-based petition may work. But for family-based petition, whether you are in status or not, especially for immediate family, for as long as the waiver is granted, you can always adjust your status, provided there are no other grounds of inadmissibility. The next question. I just answered that. I met my boyfriend while on a poor visa. Can I get green card through marriage? Yeah, I think I just answered that. I mean, like I said, if your J1 A4 visa does not have the foreign residency requirement, you may be able to get green card through marriage. If it has the 2-year foreign residency requirement, you will need to apply for a waiver of the 2-year foreign residency requirement. If the waiver is granted, you may be able to adjust status. But if the waiver is not granted, you cannot adjust status by marriage to a U.S. citizen. The next question. Can I sponsor an undocumented person to a J1 visa? It is unlikely going to be approved because if the person has entered the U.S. as an undocumented alien, if that person step out of the U.S., he or she will be barred from returning to the U.S. for a period of 10 years. So that is a 10-year bar. So because of that, even if you sponsor the J1 is unlikely going to be approved. Okay, I don't think I have any other. Are there any other questions there? Yeah, we are discussing visa for nannies here today. That is what we are discussing today, visas for nannies. And we've been explaining it. There are 3 ways to bring a nanny to the United States. The first option, well, there are 2 basic ways, non-immigrant ways and immigrant ways. Under the non-immigrant ways, we have 3 ways to bring a nanny to the United States. The first option is to bring in the nanny as a B1 visitor for business. This is usually the case where the petitioner, where the sponsor, maybe they already have a nanny who has been living with them overseas and then they are coming to the US, they need to come with the nanny so they can apply for B1 visa for the nanny. That is one option. The second option is to bring in a nanny through what is called H2B visa. H2B, okay, before I go into the second option, under the B1 visa, the maximum a nanny can stay in the US under B1 is 6 months. Now, the second option is H2B. H2B, you can bring a nanny through H2B visa. H2B visa is usually valid for 10 months, and the nanny can be with you for a 10-month period, but it is also renewable. The third way to bring a nanny to the US is what is called OPOR visa. I mean, it is a French word. The spelling is AU space PAIR, like pear, when you pair something. But they said the pronunciation is OPOR. So I'm not a French person, so bear with me. So that is the third way. So when you bring somebody in with OPOR visa, that one is valid up to 1 year. It is also renewable. But of course, unlike the employer is going to pay the nanny, and then that amount cannot be less than how much nannies in the United States get paid. So the amount must be equal to or higher than what nannies here in the US are paid. Then for the OPOR visa, that does not require a salary because that requires that the nanny will live in. Is a living situation. The nanny is required to live in with the U.S. citizen or a permanent resident. But the U.S. citizen must provide boarding, feeding, and stipend. Of course, this is the OPOR visa is also limited to ages 18 and 26. And then with if the nanny want to go to school, is he or she is allowed to go to school while on a OPOR visa. In addition, if the U.S. citizen or permanent resident sponsor, if they have an infant that is under 3 months old, the nanny is not permitted to stay with that child alone. He or she must be with that child in the presence of another adult, except if that nanny has with the U.S. citizen or permanent resident. But where they to live with the child, the 3 month, the young child, the child that is below 3 months. But where there is no specific training, the nanny can only be in the presence of the child in company of an adult. So do we have more questions? Okay, can I? Okay, the next question. Can a man get a visa through any of these programs? Oh yes, oh yes. Immigration law is not discriminatory. Everything that a woman can get under immigration law, men can also get it. Immigration law is not gender biased. Everything a woman can get, a man can get. I mean, you can imagine if a man can get VAWA, it's something that was even specifically named after women. Violence Against Women's Act. So it didn't say violence against man, but yet men can get it. Oh yes, everything here, yes, men can get it as well. The next question. Can a U.S. citizen petition for a specific person for au pair visa, or do you have to go through agency and match with someone? You can do both. A U.S. citizen can do both. You can petition for a specific person. However, that specific person must still go through all the requirements, including going through a background check, including going through medical examination, including having minimum of high school degree, being able to speak English. You must meet all the requirements. You must meet all the requirements. It's like it's like a case of adoption. A U.S. citizen can adopt a specific person. A U.S. citizen can also adopt through agency. So in this case, yes, you can do both. A U.S. citizen can do both. The next question. Can a family with a special need, with a special need child pursue this option? Oh yes. Oh yes. A family with a special need child can pursue the option for as long as they themselves meet the requirement. Remember, this is a double-edged sword. While you are protecting the American citizen, the law also protects the foreigner, the nanny. So that is why they have hotlines for nannies who are being abused. So yes, a U.S. citizen can with a special need can pursue the option for as long as the nanny is not abused, and of course the U.S. citizen is also protected. But both are protected under this program, and both can follow through this program. Now, I've explained all the non-immigrant options. Now, let me explain the immigrant option, because somebody asked a question before whether this can lead to a green card. Oh yes, this can actually lead to a green card. The U.S. citizen sponsor can go through a process of labor certification in order to make this permanent and get a green card for the nanny. Yeah, under I think it's under 3EW category. Yeah, under EB3. That's what that's what it means, under EB3. Yeah, they can go through a process of labor certification and then apply for green card under EB3 category. Now, for those who are not familiar with what is labor certification simply means that the employer must first offer the position. In this case, the nanny position. The US citizen must place an advert in major newspapers and online, where American citizens go to look for employment, job search website. The American citizen must also place advertisement with the state workforce agency, where American citizens go to apply for unemployment. So all these advertisements must be placed by the US citizen. If after carrying out all these recruitment steps, if there are no US citizen who is willing or who is able to take up this employment, then the US citizen can offer that position to the foreigner, and then they can make it permanent. Once the labor certification is approved, then the US citizen can file Form I-140, immigrant petition for alien worker, for the foreigner, and then the foreigner can apply for green card under EB3 category. Yes, it is possible for someone to get a green card through nanny. So, any new question? So keep the questions coming in. Today we are discussing visas for nannies. We are discussing visas for nannies. And I've explained there are two ways to bring a nanny into the United States. One can do it through non-immigrant visa or through an immigrant visa. Under the non-immigrant visa, there are three categories. Usually for US citizens or permanent residents or even foreigners who already are living with the nanny in a foreign country and desire to come to the US with the nanny, they can apply for B1 visa for that nanny. In such a situation, the nanny is only permitted to stay a maximum period of 6 months in the United States. The second way under the non-immigrant visa is to bring in a nanny through H-2B visa. H-2B visa is a temporary visa that is valid for 10 months, but it is renewable. In such a situation, the US citizen or permanent resident must have a contract with the nanny. And of course, the contract must state the terms and conditions of the employment. The contract must also state the minimum salary that the US citizen is going to pay the nanny. This salary must not be less than what nannies are paid in the United States. So that is the second way. So the third way under the non-immigrant category of bringing a nanny into the United States is what is called OPA visa. The OPA visa is valid for a period of 1 year, but it is also renewable. But for somebody to be eligible under the OPA visa, one, they must be between ages 18 and 26. Secondly, they must have minimum of high school, and of course, they must be able to speak English. So they are required to live with the US citizen or the permanent resident. So the US citizen will provide boarding, that is accommodation, and feeding, and also stipend. So if this nanny desire to go to school, they are under 3 months old. A nanny under OPA visa cannot stay with that child alone. He or she will have to be with that child in the presence of another adult, except where the nanny is specifically trained. If the nanny has a training to take care of infant, if the nanny has infant child care training, yes, they may be able to stay alone with that child. So those are the different ways to bring nannies to the United States under the non-immigrant category. As for the immigrant category, that requires that the U.S. citizen who desire to bring the nanny must go through a process of labor certification. Labor certification simply means that they must advertise the position, offer the position to American citizens first. Only if there are no American citizen who is willing to take up the job. The next question, is it okay? Is this Where are we? Can a family with a special need? I already answered that. Is this EB3 visa subject to visa bulletin? Oh yes, oh yes. Every employment based permanent. Remember when I was explaining earlier, I stated that when it comes to non-immigrant visas, visa bulletin is not relevant. But when it comes to immigrant visa, yes, every immigrant visa is subject to visa bulletin. When we are talking about immigrant visa, we are talking about green card. It's not temporary. It is green card. Every green card is subject to visa bulletin with the exception of immediate family members. That is the only category that is not subject to visa bulletin when it comes to green card. Every other category is subject to visa bulletin when we are talking about green card. The next question, can the au pair on J1 visa work somewhere else on the weekends? I doubt it. I doubt it. No. The answer is no, because the au pair visa is required to live with the American citizen. The American citizen is required to provide accommodation and feeding. And of course, because of all the background check, all the processing requirement involved, if the nanny is allowed to go to a different family, then that petitioner may not be able to guarantee what happened at the other location. No, it's not allowed. It's not allowed. Except where it was included in the application before approval. For example, if two different families decide to sponsor au pair visa, and each of them will provide to the consulate that, okay, this person is going to be with my family from Monday to Wednesday, and then from Thursday to Sunday, they are going to be with the other family. Where that was pre-arranged and that was stated in the approval, that was included in the approval, that may be possible. But except for that, that is not possible. And to be sincere, I've not even seen that happen. But I just know that that may be possible, but I've not seen it happen before. The next question. Is it possible to get a visa through a family member through any of the nanny program? For a family member. Yeah, it doesn't matter whether the US citizen is a family member or not. The only thing is, when it comes to family member, there must be evidence that the position is legitimate. It is not a fake position. It's not something done just for the purpose of bringing someone into the US. No, the immigration law frowns at that. The position must be legitimate. Remember, especially if you are planning of making it permanent, they have to go through the process of labor certification. And again, for family member, it may be, while the law does not expressly prohibit it, it may also be difficult, because one of the aim of a J visa is cultural exchange. So if you are sponsoring a family member, there is no culture to exchange. You already have the same culture. So you already have the same culture. You are the same family. So you are not learning any new thing. The US is not going to learn anything new from that person. And that person is not going to learn anything new as well. So that may defeat the original purpose of a J visa, because every J visa, irrespective of the category, the primary purpose of a J visa is to exchange culture, is cultural exchange. So if you are talking about a family member, this may be a question you will have to contend with at the embassy. But again, the law does not expressly ban it. The law does not expressly ban family member, but being a family member may raise question as to the legitimacy of the offered position. It may raise question as to the legitimacy. Other than that, the law does not frown at it. Do we have any more questions? Okay, in the absence of any other question, we will be hanging up today at this time. Remember to join us next week, Wednesday, 12 p.m. Dallas time, 1 p.m. Eastern time, and also currently 7 p.m. Nigerian time. Remember to invite your family, friends, and colleagues. You will agree with me that we have been providing a lot of useful information on this program. So the only way to show appreciation is to invite others so that others too can learn from all of this. And of course, the more the merrier. The more people have the right information, the less mistakes that people will make, and that will be our delight as well. So remember to subscribe to our channel so that whenever we go live, you will be notified. Thank you again for joining us. We hope to see you next week. This is Dr. Olu Asekun. Have a happy new year 2024. Change of status from B2. Am I still on live? Okay. Before I hang up, the question that I wanted to clarify, whether someone can change from B2 visiting visa to J1, the answer is yes. One can change from B2 visa to a J1. However, once the J1 is approved, the applicant will be subject to 2-year foreign residency requirement. And again, the applicant must be in status at the time of application for a change of status from B visa to J1 visa. Thank you again. We hope to see you next week. God bless you. Happy New Year 2024. To put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. It's okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, Wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.